You're listening to an African Elements top news story for June 26, 2025. Please visit our website at africanelements.org for more daily news. Supreme Court limits Medicaid patient choice. For many, the ability to choose one's own healthcare provider is a fundamental expectation. However, a recent decision by the U.S. Supreme Court has significantly altered this landscape for millions of Americans who rely on Medicaid for their health insurance. On June 25, 2025, in a 6-3 ruling, the court declared that Medicaid beneficiaries cannot sue states under Section 1983 for denying them their choice of health care provider. This landmark case, Medina v. Planned Parenthood South Atlantic, centered on a crucial legal question. Does the Medicaid free choice of provider provision clearly grant individuals a right to choose a specific provider? And can this right be enforced through a federal civil rights law known as Section 1983? The court's majority opinion, penned by Justice Neil Gorsuch, concluded that the Medicaid statute did not clearly and unambiguously confer such an individual right to sue. This ruling effectively overturned lower court decisions that had sided with Planned Parenthood and Medicaid patients. It marked a significant shift in how federal rights can be enforced. The origins of this pivotal case trace back to South Carolina's efforts to exclude Planned Parenthood from its Medicaid program. In July 2018, South Carolina Governor Henry McMaster issued an executive order that barred Medicaid reimbursement for healthcare providers in the state that offered abortion care. This action effectively aimed to defund Planned Parenthood. Federal law already prohibits the use of Medicaid funds for abortion services with limited exceptions. Planned Parenthood is a vital provider of a wide array of healthcare services. These include family planning, cancer screenings, and prenatal care for millions of Medicaid beneficiaries. Only about 4% of Planned Parenthood services nationwide were related to abortion as of 2022. Medicaid patients, many of whom are low-income individuals, often rely on Planned Parenthood due to its accessibility and expertise. The attempt to exclude Planned Parenthood directly impacts access to essential non-abortion healthcare services for vulnerable populations. Julie Edwards, a Medicaid patient in South Carolina, joined Planned Parenthood in suing the state. They argued that South Carolina was violating the federal Medicare and Medicaid Act's free choice of provider requirement. The Supreme Court's decision in Medina v. Planned Parenthood South Atlantic hinges on the interpretation of whether the Medicaid statute unambiguously grants an individual right that can be enforced through Section 1983. Section 1983 is a critical federal civil rights law that allows individuals to sue state and local government officials for violations of their federally protected rights. It provides a private right of action, meaning individuals can directly bring lawsuits to ensure their rights are upheld. This ruling stands in stark contrast to a 2023 decision in Health and Hospital Corporation of Marion County v. Talevski. In Talevski, the court affirmed that patients do possess a private right of action to enforce certain conditions that federal Medicaid law imposes. Medina is considered a departure because it did not articulate a clear legal rule for lower courts to apply. Justice Gorsuch's opinion focused on specific features of the law at issue rather than providing a broad framework. This has been interpreted as a step back from the Talevski precedent. It potentially limits the ability of beneficiaries to sue to enforce other Medicaid rights. The court emphasized that the typical remedy for non-compliance with Medicaid statutes is for the federal government to cut off funds to a state. It did not support allowing individual lawsuits. The Medina ruling carries significant implications for healthcare access. Over 78 million Americans depend on Medicaid. By limiting the ability of beneficiaries to sue states under Section 1983 to enforce the free choice of provider provision, the decision removes a critical legal avenue. This could lead to reduced access to care, especially for services offered by providers like Planned Parenthood, even if those services are not related to abortion. For many Medicaid beneficiaries, this may mean fewer choices of providers, longer travel times, or complete lack of access. Justice Ketanji Brown Jackson, joined by Justices Sonia Sotomayor and Elena Kagan, voiced a powerful dissent. She argued that the ruling stymies one of the country's great civil rights laws and will result in tangible harm to real people. Her dissent emphasized that the decision could strip Medicaid recipients of a deeply personal freedom. That freedom is the ability to decide who treats them at their most vulnerable. This perspective underscores the potential for the ruling to disproportionately affect African American and low-income communities. These communities are often more reliant on Medicaid and face greater barriers to accessing care. The decision could also enable states to exclude providers based on other characteristics. These could include union affiliation or the provision of gender-affirming care. This would further limit patient choice and create a fragmented healthcare landscape. The Medina decision could embolden more states to follow the path of Arkansas, Missouri, and Texas. These states have already barred Planned Parenthood from receiving Medicaid reimbursement for any kind of healthcare. This ruling creates a significant challenge for Medicaid beneficiaries who wish to challenge provider exclusions. Their direct legal recourse through Section 1983 has been severely curtailed. The decision highlights a growing tension between state control and federal oversight in Medicaid programs. The future of healthcare access for millions of Americans remains uncertain, particularly for those in marginalized communities. There is potential for further limitations on their ability to choose their own medical providers. Copyright African Elements,